But we started to learn, probably even with the GDPR, that there is no pond. It's what happens in Europe happens here simultaneously, because businesses operating are in both jurisdictions and have to cope with what other jurisdictions impose on them. So the Digital Markets Act went through a gestation period a little bit longer than that of the FTC merger guidelines, considerably longer, I think. Again, was the product of, or at least involved a number of rounds of comments and public proceedings, and has emerged as perhaps the most significant feature of the digital era in terms of its effect on business, maybe second to the internet, as you will learn in a few moments. The act became effective last year, and the deadline for compliance is weeks away. And so firms all over the world that do business in Europe have been feverishly dealing with the compliance issues that arise, and we'll hear about some of them, as well as the difficulties of implementation. And then we will branch out a little bit beyond the DMA, because it turns out that the DMA is the subject of a lot of potential imitators from other jurisdictions outside the European Union, some of which will be similar, some of which will be somewhat different. And so the world is getting even more complex without much more time passing. So let's begin. We have a great panel here today. Neil Chilson, who's going to speak first. In addition to, you see everyone's present positions in your program. Neil was previously the chief technologist at the Federal Trade Commission. How the world has changed. There's a chief technologist at the Federal Trade Commission, or at least there was. Maybe you were the last one.
There was a gap, and I think they're back now.
All right, why don't you start us off, Neil?
Sure.
So I guess I'll just say about the other members of our panel. As you can see, Beatriz Marques who will actually be speaking third, is an enforcement official at our neighboring jurisdiction in New York, and has an advanced degree in European competition law, so she brings a lot to this discussion. And Nikhil, very senior in the legal department at Meta, so if he feels a little bit embattled, you'll understand why. By the world, not by the panel. Okay. All right, Neil.
Thanks. Good morning. Thank you, Judge, and thanks to the staff of the George Mason Law School and Law Review for organizing this event. My role today is primarily to be your tour guide, giving an overview of the topic of this panel, the Digital Markets Act. Don't worry, this won't be a boring, objective tour of the sites, just reciting article after article of the DMA and timelines. This is going to be an opinionated tour from a loud, maybe boorish American who's toured the sites a little and thinks he knows everything about them, but who no doubt misses some of the sophisticated terms, the nuances of sophisticated terms like proportionality and fair and contestable. So come with me, lay your Constitution down and your cost-benefit analysis, and let's fly across the pond, which no longer exists, to Brussels, where the continent's brightest minds are hard at work regulating things that the United States just invented. So here we are, the seat of the European Union. There are 6 stops on this tour, okay? We're gonna talk about where, we're gonna talk about why, talk about when, or what, who, when, and how. Although you already mentioned the when a little, so maybe that'll be a little pit stop. So our first stop here, where, is pretty straightforward, right? We're in the European Union. It's a supranational political economic union of 27 member states. I got that from Wikipedia. These countries who have spent significant chunks of previous millennia trying to kill each other are now getting along fabulously. So it turns out It turns out they all like to make paperwork. Who knew? And so that's the where, pretty quick. Let's move on to the why. And the why is actually, I'm joking about the obviously complicated nature of the European Union, but the why for the DMA comes straight out of that complicated nature, which is that 27 countries with very different backgrounds, tensions, different ecosystems, they're trying to figure out how to make the union more perfect. And the Digital Single Market Initiative is a big push in that direction. And the DMA is one part of that initiative. The goal of the Single Market Initiative is to increase digital innovation, efficiency, and productivity. And the means by which it wants to do that is to increase regulatory harmony across the EU member states. Other rules and legislation that we might talk about, regulations that we might talk about, like the DSA and the AI Act, are part of this initiative, but the DMA is obviously the most pertinent right now. But the DMA is not a replacement for, while the DMA focuses very much on market effects and on improving markets, it's not a replacement. It very clearly states it's not a replacement for competition law within the EU. It is intended to complement EU antitrust laws with a different goal. Whereas the goal of EU competition law is to promote and preserve undistorted competition, the DMA's goal is to preserve and promote fair and contestable markets, which is different apparently different than undistorted competition. So what are fair and contestable markets? Well, that's our next stop, the what. So here we are. Look up. Can you see the DMA? It's there. It's in front of you. It's huge, right? It's blurry outlines. There's a lot of moving parts. But let's maybe try to get the outline together in our minds. And I think maybe I'll try to use an analogy to get there. An analogy to US law, perhaps. It's a little hard to describe the DMA by analogy to US law. It is like antitrust law, as I've already mentioned, in that it's focused on improving market outcomes, and it covers a wide range of industries, sort of like the general antitrust laws of the US. Unlike US antitrust law, it's pretty prescriptive. It's an ex-ante regulatory approach. So maybe in antitrust law, that's kind of like the era of like per se rules of some kind. But those regulations only apply to a select group of companies and services that are designated by the enforcer. And this designation process sort of looks like in the US, maybe like a trial where the defendants are guilty, and then and the substance of the DMA is the settlement that comes, or the court order that comes after. So on the other hand, if you look at it so maybe it's antitrust law, maybe it's regulatory law. On the other hand, if you look at which companies have been singled out, maybe it's more like tariffs or trade policy of some kind. But for now, let's just imagine it's antitrust law, but it's the antitrust law where there's one per se rule, which is if you're big and successful, you're under this. And then the settlement is all the conditions, the fencing in that goes around the types of behavior that a large market participant might take on. So we'll get into like what the how of the DMA a little bit later. But there's a bunch of things that they can do and that they can't do regarding services, once you're designated as a gatekeeper, regarding services that other people who are not designated as gatekeepers can or can't do respectively. So, and there's some of those per se rules that I mentioned that haven't really been fully worked out. They're being worked out in process. To get a little bit more specific about the what, let's talk about the core platform services that are targeted by the DMA. This is online intermediation services, which are app stores essentially, search engines, social networking services, video sharing platform services, number-independent interpersonal communication services, which are essentially text messaging apps, operating systems, web browsers, virtual assistants, cloud computing services, online advertising services. Which is a lot of things. I mean, it's a lot. That's a big chunk of the internet. It's a lot of different things for one law, which is why it doesn't exactly look like industry-specific regulation. But what do all these different things have in common? Well, they all involve computers and the internet, so they're digital, and they all are services offered by some of the biggest companies in the world. So that's one thing that they definitely have in common. So it might be a regulation that's about our next stop. It's not so much about the what, but it's about the who. So who is the who? On to our next stop. The who is gatekeepers. If a company offers core platform services, it might be a gatekeeper. How do you know if a company is a gatekeeper? Basically, according to the DMA, I've already kind of signaled this a little bit, and I'm very much glossing over all the details. But if a company offering a core platform service is a gatekeeper if it brings in a lot of money and it has a lot of business and customers. And so and those thresholds are quite high. So it doesn't cover a lot of people, or a lot of organizations. But that is the definition of a gatekeeper. Now, market share and evidence of anti-competitive activity are not important to this determination. In fact, the regulation declares that, quote, justification on economic grounds seeking to enter into market definition or to demonstrate efficiencies should be discarded as it is not relevant to the designation as a gatekeeper. There are some defined financial and active end user, business user default thresholds that I already mentioned, but if your company doesn't quite meet those thresholds, there's a whole bunch of other factors that might mean that you are still a gatekeeper and subject to the DMA. So where are we right now? As of last September, as the judge mentioned, the EU designated Alphabet, Amazon, Apple, ByteDance, Meta, and Microsoft as gatekeepers with 22 services offered by these companies identified. They did leave out some services, right? So Gmail is not a covered service, Outlook.com, Samsung's internet browser, and there are several other services that are ongoing in discussions about whether or not they will fall under the DMA. So that's the who. Let's move. We already talked about the when, but just to add a little bit more detail, when the gatekeepers were announced in September, that gives 6 months to come into compliance, and so that date is coming very quickly. So we've seen the where, the why, the what, the when, the who. Let's pause for an espresso, maybe. We don't have time, so we're not going to pause for an espresso before our final stop on this tour, which is the how. And this one's a doozy, so let's get there. I'm not going to cover all of the requirements. There's a bunch in here, but I'm going to kind of cluster them a little bit. So there's reporting obligations. The first ones that come up are reporting obligations to the European Commission if you think you might be subject to being a gatekeeper. And so you have to file if you think you're going to maybe qualify as a gatekeeper. Gatekeepers then on reporting obligations, once they're determined to be a gatekeeper, they have to file periodic compliance reports that tell the commission how they're complying. There's a long template, which is helpful. And it looks, when I was reading through it, Beatriz was helpful enough to send a copy of it. And what it looks like, and what made me think of the analogy is that it looks like the civil investigative demands that the FTC sends when they're bringing a case against a company, which kind of makes sense here. But the substantive requirements of the DMA are in Article 5 and 6, and they cover a wide range of single firm conduct, I guess you would say. And I guess you could think of this as a bunch of per se rules under antitrust law, but it really is regulatory obligations. There's a wide range of them. They involve getting consent before using data for users. Can't stop direct-to-consumer sales channels, so you can't stop people from linking out to purchase a product from the app that's on your iPhone or whatever. You have to give businesses and users data access. This includes advertisers and publishers. They have to have tools to be able to find out about how their ads are working. Article 6 has a lot of other things. The ones I think that we've probably heard the most about are side loading on mobile OS systems. There's interesting things about search engines about not being able to rank your results above others on your search engine, not being able to use the business data of your customers to inform your own business plans in certain ways. Access to performance tools, there's data portability obligations, there's an interesting section that I would like to dig into because it's very interesting to me about like all ranking and click data that needs to go to competing search engines. You have to provide that so that they can improve their search engines. Maybe that's not exactly what it says, but that's what it sort of sounded like it said. And so, and there's some obligations around the interoperability of messaging platforms in Article 7. I'm sure I missed a bunch, but the point is here, there's a lot here. And so you're talking about a narrow range of companies who are designated to be under this close watch with a bunch of obligations. I think probably these companies are setting aside budget to deal with European fines at this point. It seems like likely to happen. And what do those fines and what are the mechanisms, what do they look like? We're talking penalties and fines of up to 10% of a company's worldwide turnover, up to 20% in the case of repeated infringements. And in the case of systematic infringements, the commission can even impose behavioral or structural remedies to ensure the effectiveness of the obligations. We're talking about breaking up companies. Or totally banning further acquisitions. So anyways, that's the tour. We're back here at Where. And before we return to the US, I'll just double click on Judge's point. Like, you're probably gonna be able to take this tour in many places other than the European Union. It seems like a lot of newer jurisdictions who are establishing regulation in this space are looking to the DMA as a template and copying it. So everyone, c'est la vie. Thanks everyone for joining me on this tour of the DMA, and I look forward to the discussion.
Thank you, Neil. It's right on time, and turn over to Nikhil.
Great. Thank you very much, Judge. And as Neil said, thanks so much to Mason and GAI for the invitation to be here today. It's always lovely to be on campus and great to be participating in this panel today with these esteemed colleagues. So Neil gave a great rundown of the Digital Markets Act, the DMA, which has been was in a legislative process for a couple of years. The designation process ran for many months. We've been in the post-designation compliance discussion process for the last many months now, and are about to hit the next phase, which is basically when the DMA obligations come into force and compliance is required, and that is the date there is March 6th. So a lot here is that we are still going to see. But I think maybe one thing I might just briefly touch on, in addition to the metes and bounds of the text of the statute that Neil very helpfully walked through, is maybe talking a little bit about purpose and motivation and where this kind of approach is coming from and what that approach really is. So very broadly speaking, the goal of the DMA is to introduce competition legislation, competition regulation, that moves away from the traditional ex post enforcement model, where we think about a company acting in a certain way, taking a certain type of conduct, looking at that after that conduct has occurred and saying, hey, there might be an antitrust violation here. Let me send out those CIDs. Let me send out RFIs as an agency, investigate that conduct, engage in a back and forth with the company with documents and interrogatories, and then reach some decision about whether I think that that conduct is violative of the antitrust laws, the very broad antitrust laws in Europe as articulated in Article 101 and 102, equivalent or roughly equivalent to our Section 1 and Section 2 in the US. And then take a decision. And that may be an administrative decision in some jurisdictions, that may be a decision to go to court in some jurisdictions, but effectively enforcement of these antitrust laws after the conduct has occurred. The goal is to shift that model to be a ex-ante regulatory model. So more in line with what we might think of as, rather than law enforcement, as a regulatory approach in the sense of telecom regulation or something similar, where there's much more of a desire by the regulator to be acting and to be assessing conduct either before it happens or while it's happening, and intervening at that point through a set of regulatory tools that go beyond the idea of this ex post enforcement and then an infringement decision at the end of that. As part of that, what the DMA does is it really eschews much of the kind of analysis and elements that we think of as part of that ex post antitrust enforcement regime. So for example, there's no requirements or thinking about sort of market definition in the DMA. There's no analysis of market power. There's no effects-based analysis of exclusion or harm to competition. There's no balancing of anti-competitive effects versus pro-competitive harms in the sense of at the point once the process has run in terms of designation of gatekeepers and CPSs, the core platform services that Nikhil mentioned, you no longer ask those questions. You no longer ask, okay, Google search has been designated as a CPS. You're not talking at that point about market power. You're not trying to define a market for search. You're not talking about, is there a pro-competitive benefit that might act as a countervailing impact on any anti-competitive harm. So as Nikhil mentioned, you can think about that sort of as unrebuttable presumptions that these types of conduct that are listed in the DMA in Article 5 and 6 are per se violative for these, at least when practiced by these gatekeeper companies with those designated CPSs. And so instead of these the sort of traditional elements of antitrust analysis, you have very specific and sort of mapped out elements of conduct that are prohibited, and those sort of follow through exactly as kind of Nikhil described. We're going to hear about other models in other places around the world in a little bit, which Beatriz is going to run through. Broadly speaking, I think you're going to hear a lot of similar themes around this idea of moving from ex post enforcement to ex ante regulation, doing away with sort of the need for competition analysis, and really applying to a very specific, a small number of specific digital companies. That's kind of maybe a core theme that runs through most of those proposals. So that's a quick review of kind of the basic motivation. As Nikhil noted, there's an incredible amount of complexity here. No one should take this primer and run off to practice DMA law. So we'll wait to develop a set of expertise around that. It'll take longer than this. I think the other thing that I would note here is it's really too early to reach any firm conclusions as to whether the DMA has met its goals and what that impact on competition and consumers might be. Certainly too early in terms of other jurisdictions where we're much more at the deliberative phase and we don't have legislation actually in place in other places, but expect that that'll come online over the next couple of years. But what I'll move to now is maybe just offering a couple of observations from the experience to date. And broadly speaking, I can sort of think about this as divided between kind of the regulatory design, how our practice has shifted as lawyers, maybe specific to in-house counsel, but I think this also applies to the outside counsel world as well, in terms of how we counsel our internal product and business teams on compliance with this kind of new regulation where there's no precedent, there's no case law, there's nothing to look to in that respect. And then maybe some of the outcomes that we're actually seeing in the market as the DMA is implemented. Obviously, we haven't seen enforcement yet, but we do have designation, and some of those dynamics, I think, can lead to some interesting observations. So maybe first talking about regulatory design, I can sort of split this up into what I see as kind of opportunities and challenges. So first, opportunities. So as I mentioned, this DMA shift from the model of ex post enforcement to ex ante regulation also really entails an intent to foster more of a participatory regulatory dialogue between regulators and the regulated companies. So that's meant to cover a broad array of topics and really involves kind of really high touch and effectively ongoing conversations about business models, changes in technology, the user experience, and any other key factors that are relevant to those services and how they're provided. And ultimately, the goal here is to have regulators have all the information that they need, good information, and hopefully reach the best outcomes with that more ongoing conversation with the companies and their motivations, their practices, et cetera. And another stated goal here is to move away from what we kind of have seen as sort of lengthy adversarial proceedings and towards maybe a more constructive and participatory approach where the focus might shift more to problem solving and getting the best outcomes for consumers. And I see a lot of potential for benefit with this shift. Over the last many months, we've already had a lot of constructive and positive engagement so far with the European Commission on the DMA. And I'm a firm believer that it's always better for regulatory decisions or enforcement decisions to be based on a strong understanding of the business that's being regulated and the products that are at question and the practices that are being seen in the market. and to really understand them from a 360 perspective. So I think it's really important that all this education and discussions actually feed into the decision-making that we're going to see in the next several months as well. So I think that's a big area of opportunity, and if we see resolutions that come out of this constructive engagement that avoid litigation and focus on user benefit, ultimately we may end up in a place that is better in many ways than, for example, having blunt injunctive orders that come at the end of an enforcement proceeding. Moving quickly to talk to some of the challenges that I see sort of in the design of the DMA. One is that the DMA's provisions are basically one size fits all. So they are written into the legislation in a very specific way, sort of thou shalt not X, thou shalt Y. And there's not recognition in the text that there are a number of, or at least not a lot of recognition in the text, that there are a number of different business models at play here, different technology stacks, different data use scenarios, different user experiences, and user functionality. That's sort of not really part of the text of the DMA. And if we end up with sort of a blanket approach where every provision applies to every gatekeeper and every CPS equally, I think we could end up in a situation where you have a lot of square pegs that are being forced into round holes, and the forest can be lost for the trees in terms of whether users are actually benefited in that process and whether the DMA's goals are furthered in practice. And I'll speak to a couple of examples of that in a couple minutes. Another issue I wanted to raise here in terms of regulatory design is the idea of private litigation. So the DMA does entail the ability for private litigants to bring actions directly under the DMA in each of the 27 member countries' court systems. So I think that could actually turn out to be quite problematic. One thing we talked about is the potential benefit of this ex-ante regulatory approach being engagement between the regulator and the regulated that results in a set of compliance solutions that meet the requirements of the law in the regulator's opinion. But if the view of the regulator in terms of the sufficiency of those compliance solutions is not durable because of the fact that you could have 27 different member states and different court outcomes in those states, I think you potentially lose a lot of that benefit of the ex-ante approach, and you end up in a world where outcomes are ultimately being driven by exactly those lengthy adversarial proceedings that we were told the DMA was supposed to try to move us away from. So I know I have about 5 minutes left. I'm going to quickly talk through some of the issues that come up in sort of counseling the business in this very new area where we don't have anything to go on. We're sort of trying to kind of build the plane as we fly it. One piece here actually relates to that continuing regulatory dialogue. We're seeing a lot more opportunity than we would in these kind of ex post enforcement scenarios to have a really deep engagement with the regulators. We see a genuine desire on all sides to make sure that we're explaining our products and services and our practices, real desire on the side of the regulators to make sure that they're understanding all of those technologies, all of those products, all the decisions, the business decisions that go into how they're offered. And the DMA process does seem to enable this at a much deeper level than I think we've sort of traditionally been used to. We've been engaging with the Commission for many, many months now and have had a lot of substantive conversations about our products and the compliance solutions that we're offering in many of those cases. And throughout that process, we've gotten a lot of really helpful and good feedback and constructive feedback from the Commission on the key elements of those compliance plans before they ever go into practice, right? So there's no actual enforcement right now, there's no actual conduct that could be the subject of enforcement, but we're already getting that feedback about sort of how regulators are seeing those solutions and whether they meet the requirements of the DMA, if not, how they could be changed to meet those requirements. And it lets us really sort of counsel our internal teams on how we can have a robust and sort of durable compliance solution with the benefit of that regulatory guidance. So that's very valuable and really appreciate that opportunity. Couple of places where I think we have, where we're seeing some challenges in terms of kind of how to think about counseling. This goes back to sort of removing those traditional elements of antitrust analysis, discussions about market definition, market power, anything about really competitive dynamics, removing that from the analysis and the process of DMA application and discussion with the regulators, I think really moves us away from the context in which these actual solutions are being offered in the market. And I think removing that context is very hard when you're trying to get to outcomes that are being driven with a motivation from competition law or competition to not think about the dynamics of competition. And it also means that you can't really use those first principles to reason from. So here's an example, going back to what I mentioned about sort of the designation. So one of the areas that could have been designated as a core platform service was Microsoft's Bing search engine. It apparently met the threshold requirements, the number of user requirements, et cetera. There was a more in-depth market investigation, and ultimately, I think just last week, the commission decided that Bing did not qualify as a CPS, but there was considerable uncertainty about that. And the very fact that that process took 9 or 10 months to resolve likely means, you could see that decision going the other way in a situation where Bing was designated as a CPS. And one of the things we saw Microsoft communicate about that process was this really ignored the dynamics of competition. If one of the goals of the DMA is to open up the contestability of markets, including areas like search, it would be a somewhat bizarre result, as Microsoft put forward, to have maybe the sort of upstart competitor in the search space have to exit the market. And they said that might be what happens because the compliance costs of being a CPS would be so high that it would not be justified on the basis of the Bing business. They might have to remove that product from Europe. So that's an area where I think you could have a problem if you have a sort of too stringent interpretation of what in some cases is pretty vague DMA language. You could end up with broken experiences for users, broken experiences for business users, advertisers in many cases. And if that type of dynamic is not taken into account in the regulatory decision making, and I think I at least have some worry that it's not sort of sufficiently of focus right now, I do think you can end up with some results that would actually make consumers worse off, and you would end up with that result if you had products that couldn't be offered anymore, or products that sort of came under such a burden that they couldn't compete effectively. So I'll stop there and hand it over to Beatriz.
Thank you, Nikhil. And Beatriz?
Thank you. Can you hear me?
Yeah.
Great. So I'd like to start by saying thank you to the George Mason Law Review and the George Mason University and my fellow panelists. I'm honored to be here today. And let me also just say my very quick disclosure. Please note that the comments I make today do not represent the views of the New York Attorney General, nor any member of her office. So with that, I'd like to start by discussing the rationale for digital ex-ante regulation as a complement to antitrust enforcement, and I'll then address a couple specific ex-ante regimes enforced today or close to implementation, including in the EU, Germany, and the UK, and how these regimes compare and contrast. And lastly, I'll address briefly other regimes and similar proposals in other jurisdictions, including, for example, in Japan, South Korea, Brazil, and Australia. And allow me to say that following that fantastic tour, since we didn't stop for an espresso, I might just have to underscore a couple points that were very well made by both Neil and Nikhil. So the rationale for ex-ante regulation as a complement to antitrust enforcement includes three common reasons we've heard across jurisdictions. So the first is that antitrust has been too slow and the remedies ineffective in this space. Meanwhile, market positions become entrenched and extend across more markets. So what we hear frequently in this context is that if we don't act urgently, then these entrenched positions become ever harder to reverse. The second is that antitrust cases tend to be slow, narrow, and backward-looking. And thus, they're not a great vehicle for forward-looking compliance to provide clear, upfront rules of the game, which also provide legal certainty to companies. And third is that some drivers of these problems are intrinsic. In other words, they don't necessarily flow from an implication of fault or abuse. And on this last point, there's been a number of high-profile reports by experts appointed by governments and regulators in recent years, which underscore that the digital space presents a confluence of several factors, not necessarily individually unique, but that when encountered together may lead to a degree of failure of the natural competitive process to deliver competitive outcomes. And among these characteristics, what we very frequently hear are the presence of strong economies of scale with low or zero marginal costs, network effects that make it easier for a platform with a large number of established users to attract more users, a data-driven feedback loop which further strengthens the network effects, economies of scope due to the role of data as a critical input, and conglomerate effects. And together, these features generate a winner-take-all dynamic where markets are prone to tipping and become highly concentrated around a single or a few single dominant platforms. And in addition, once the market has tipped, the dominant player frequently gains a gatekeeper status with the power to dictate the terms to its digital spaces for other firms, amplifying barriers to entry for potential competitors. So in order to address these conditions, over the past years, many jurisdictions have proposed some form of ex-ante regulation to complement the existing ex-post competition law enforcement. Broadly speaking, and as already underscored by Nikhil, the initiatives on ex-ante rules are intended to ensure openness, fairness, contestability is the one we always hear, transparency, and innovation. And generally, the ex-ante regimes include a designation process, conduct obligations, whether tailored to the specific gatekeepers or general list of do's and don'ts. And most regimes also include murder reporting obligations for designated entities. So turning to the specific ex-ante regimes, probably the first such regime, and which you've already heard about today, that comes to mind is the European Union's Digital Markets Act, or DMA. As Judge Ginsburg underscored, it entered into force on November 1st, 2022, with the aim to minimize harmful structural effects and prevent unfair practices ex ante by setting a list of obligations or prohibitions applicable to gatekeepers. And gatekeepers are defined as large digital platforms providing so-called core platform services, such as, for example, online search engines, app stores, and online social networking services. And these are companies that play a particularly important role in the EU internal market because of their sheer size. I think, as Neil put it, just so much money, and their importance as gateways for business users to reach their customers, which enjoy an entrenched and durable position. So in September, the European Commission designated, as you've already heard, 6 gatekeepers and 22 core platform services provided by those gatekeepers, including, for example, Google Search, as of the core platform examples, Google Search, Facebook and Instagram, and Google's Android and Apple's iOS operating systems. And the gatekeeper obligations of the DMA are in principle self-executing. So the gatekeepers are required to implement the do's and don'ts by themselves. To ensure compliance with the DMA, the gatekeeper must, among other things, establish a compliance function, and they are subject to audit and reporting obligations that place a burden of proof on the gatekeeper for compliance with the DMA. And importantly, while Article 5 of the DMA is directly implementable, including, for example, obligations for gatekeepers to refrain from combining personal data from core platform services with any other services, or refrain from requiring users to rely on an authentication service of the gatekeeper, Article 6 and 7 provide for further specification by the European Commission where this may be necessary. Article 6, for example, covers obligations such as the prohibition on self-preferencing and an obligation to allow sideloading. So this means that if the European Commission considers measures taken are not compliant, it can specify alternative measures. And gatekeepers can also request a determination on whether the measures they propose are considered effective. And notably, as also already mentioned by Neil, if the gatekeeper violates the new rules, it risks a fine of up to 10% of the total worldwide turnover, and harsher sanctions are foreseen in the event of repeated or systematic infringement, which is following 3 non-compliance decisions. And this could include fees of up to 20% worldwide turnover, and behavioral and structural remedies. And again, yes, including breakup. And as has also been mentioned, the obligations will become applicable imminently on the 6th of March at midnight. So allow me to turn now to other regimes, starting with Germany. So in Germany, the 10th Amendment of the German Competition Act in 2021 incorporated Section 19A with the aim of allowing the Bundeskartellamt, and that is the federal cartel office which enforces competition law in Germany, to intervene earlier and more effectively against the practices of digital companies. Section 19A allows the Bundeskartellamt to designate companies of paramount significance for competition across markets. And note that this is a different term than gatekeeper, but each jurisdiction has adopted its own terminology. So once a company has been designated, the Bundeskartellamt may prohibit these companies from engaging in certain anti-competitive practices as part of a two-step approach. So the first step outlined in Section 19A1 provides a designation of these companies taking into account particular factors, whether a company holds a dominant position in one or several markets, its financial strength, its vertical integration or conglomerate activities in related markets, its access to data relevant to competition, and its intermediation power. And notably, the list is not exhaustive, and the Bundeskartellamt does not need to establish all of these factors in its designation decision. And importantly, unlike the DMA, the designation applies to the entity's entire ecosystem and not solely to the designated core platform services. The second step outlined in Section 19A2 lists a variety of conduct that may be deemed problematic from a competition perspective, if the relevant company is designated as having paramount significance. And these include, for example, self-preferencing, refusing interoperability of products or services, refusing data portability, and creating barriers to entry based on the user data a company has accumulated. Unlike the DMA, Section 19A's obligations are not self-executing. Before issuing a prohibition decision, the Bundeskartellamt conducts a qualitative assessment of the companies that are subject to Article 19A on a case-by-case basis. So this is not a one-size-fits-all type of solution. And unlike the DMA, also there is an efficiency defense with a shift of the burden of proof to the company. To date, the Bundeskartellamt has designated 5 companies, including Alphabet, Amazon, Apple, Meta, and Microsoft. Following the designations, the Bundeskartellamt has launched several 19A2 investigations, many of which are ongoing. Interestingly, in connection with the Bundeskartellamt's Section 19A investigation of Google processing terms, here the Bundeskartellamt underscored that the Section 19A goes beyond the DMA and is complementary. Allow me to turn now to the UK. So in the UK, the Digital Markets Competition and Consumer Bill, which would enable the Digital Markets Unit, or DMU, of the Competition Markets Authority to designate firms with strategic market status, is currently at the report stage in the House of Lords following introduction in the House of Commons. So strategic market status, or SMS, is the UK's chosen terminology rather than gatekeeper. The bill is expected to receive royal assent and become law this year. And currently, as it's proposed, firms with strategic market status must have substantial and entrenched market power in a digital activity, which is linked to the UK, a position of strategic significance, and a global turnover of more than £25 billion or more than £1 billion in the UK. So before a firm is designated, the DMU will conduct investigations with a time limit of 9 months. And once a firm is designated, the DMU will have 2 key tools. One are conduct requirements, and the other are pro-competitive interventions. Notably, like the DMA, here the tools will apply in relation to only specific digital activity of the firm with strategic market status and not across ecosystems like Section 19A. Conduct requirements will set out how a SMS firm must conduct itself in relation to digital activity, and they will likely vary across firms and digital activities based on the DMU designation. So again, this is not a one-size-fits-all. It will be very specific to the firms and the particular digital activities. In other words, the DMU will create a bespoke code of conduct for each SMS firm that addresses the particular harms associated with the SMS firm's activities. And in contrast, as previously discussed, the EU DMA contains a list of do's and don'ts that apply universally to gatekeepers. Moreover, under the UK's DMU, SMS firms may be exempt from complying with applicable codes of conduct subject to efficiencies. And as aforementioned in the EU, there is no such thing as an efficiency defense in terms of the DMU, in terms of the DMA, excuse me. As to the pro-competitive interventions, these might be required by the DMU following a 9-month kind of market study, and these might include both structural and behavioral remedies. So one thing to note as to the PCIs is that this is a faster mechanism for the UK in contrast with the EU DMA, where systematic infringement, meaning at least 3 non-compliance decisions, are required before a structural remedy might be considered. So PCIs might bring breakups quicker. So finally, please note that beyond the EU, Germany, and UK, there are multiple ex-ante proposals that are being considered across jurisdictions. For example, Japanese lawmakers are preparing legislation that requires companies like Apple and Google to allow other app stores or payment processors onto their iPhone ecosystems. And this is similar to the law that was passed in South Korea in 2021 as part of an amendment to the Telecommunications Business Act, which bans app store operators from forcing software developers to use their payment systems. In Australia, as part of the digital platform inquiry being carried out by their competition enforcer, the ACCC, a similar ex-ante regulation than that in the UK has been proposed as of 2022, which is undergoing legislative review. And in Brazil, the government has launched a public consultation on whether a DMA-like statute is required. So many other jurisdictions have launched similar consultations, going beyond the ones I've mentioned, including, for example, Turkey and India. I think to date, the only global consensus across enforcers is the desire to protect competition in digital markets in the face of the perceived overwhelming market power by large platforms. Despite this common goal, it's uncertain whether most jurisdictions will ultimately adopt the ex-ante approach or whether they'll ultimately determine that competition law is sufficiently effective in addressing the specific features of digital platforms. I think only time will tell. Thank you very much.
Thank you. That's terrific. So the problems are only multiplying as we proceed, problems being complexity, coordination. So let me ask a couple of questions to get things going, but I want you all to, well, I'll let you all start. Go ahead, Neil. If you have comments or questions to your successors here.
I was just trying to make sure this was off so that it wasn't echoing. But I think my big picture question here is, what does success look like for the DMA? I heard a lot about, I laid out the context of it being part of the single market initiative. And when I hear that there's overlapping jurisdictions that are doing different things, it doesn't seem like it's accomplishing that particular goal, or it's driving something different than that. And so there's on that end, and then on the innovation end, where the goal is to keep these markets contestable. I mean, would the European Commission consider it a success when there's a European company that qualifies, that has this determination, or is the goal to keep something different? It's not clear to me what success looks like here, and I'm curious what you guys think about that, since you've both dove a lot deeper on that.
I'm happy to comment first. I think what success looks like here is if we think of the saga of Google cases in the European Union that started with investigations in 2010, and then were split into different ones, and we had the first decision accusing Google for its shopping decision for abusing dominant position. That's in 2017, and we're still waiting to hear from the Court of Justice in the European Union. I mean, success means coming to quicker resolutions. So I think that's one, and let me pass it on to Nikhil.
Yeah, I think that's a really good example. I might add one qualification to that, though, right? One of the motivations behind the provisions, and Neil did a great job of running through them, there's a lot of them. It is worth actually looking at Articles 5, 6, and 7 to understand kind of the scope of what the actual conduct prohibitions or requirements are. They do differ, and you can come to different decisions about each of them as to whether substantively they're justified or not. We talked a lot about process, but what we didn't get into, I think appropriately, is whether each of those provisions actually makes sense. The one that Beatriz mentioned is the one on sort of the prohibition of self-preferencing in crawling and ranking services, clearly motivated by the Google search cases in Europe as they're working through the courts. At least one of the frameworks that has been put forward is we are so sure that these types of conduct are problematic and anti-competitive that it now makes sense to embody those and encode those as regulatory prohibitions. We no longer need to ask about effects on the market. We no longer need to ask about countervailing benefits. We've already reached a conclusion. As Beatriz just mentioned, the Court of Justice has not ruled on that. So the Commission may have reached a decision on that question, but the courts of even the European Union have not reached that decision. And it's not clear that in all those other provisions, you would also see sort of court decisions from the courts in Europe or the highest courts in Europe that would say, yes, these are all so clearly problematic that they can be barred per se or should be barred per se. So that's just a point about kind of the substance on some of the prohibitions.
Well, I think that's an important contrast with the way in which we historically have approached per se prohibitions, which analogous to ex ante prohibitions, which is to say, based on sufficient repetitions and evidence that the process of inquiry was no longer worth the candle because these things are always, virtually always, anti-competitive, price fixing, market allocations, and so on. And then when the government sought to a prohibition on certain technical tying arrangements in the Microsoft case, the court said, no, there isn't enough experience to make that kind of a decision. So it's empirically charged from beginning to end. And so my question here is there case or even administrative experience with each of these major prohibitions that gives some of the same assurance that it's always anti-competitive?
If I may,
Please.
I think one reaction is that despite the cases, can you hear me?
Your light's on, let's try it.
And now?
There you go.
Thank you. So one reaction is that, yes, despite the cases haven't reached the European Court of Justice, so kind of the Supreme Court, the highest court, the General Court has indeed very favorably agreed with the European Commission in these cases. And I think where there is experience, one could say, is that because the remedies weren't frozen while the appeal process was ongoing, there's a lot of experience on the remedies that were applied in Europe, as to, for example, the Google search case and the Google Android case, and a general sense that they just haven't worked, which is why or how the DMA was informed to these general prohibitions as to how they think that they can make markets more contestable. And to go to Neil's point as to, will these apply to a future European gatekeeper? I certainly hope so. And I think that hopefully we'll have that European gatekeeper thanks to making these markets contestable.
So is there any evidence or what shall I say, discontinuities in the criteria that suggest to you that they were gerrymandered to exclude all but American companies? We saw that in legislative proposals in the U.S. Coming from, for instance, Senator Klobuchar's, which were designed to make sure that Minnesota companies, were major ones, were not included. Anything like that? Anybody detects? Anybody with a suspicious mind? Cecile?
Actually, I was at an event in Brussels last year in December, and I was told specifically by European Union officials that the DMA was created in order to improve the ability of European firms to enter these markets, and that they would know that it was successful if, in fact, in a few years, there were European firms involved in these areas.
Probably without taking into account the fact that a growing European firm may want to stop growing before it hits the thresholds for DMA coverage.
Can I add a little point on that as well, which is there's a tension a little bit in the approach of having a very participatory back and forth with incumbents between the regulator and trying to foster startup disruptive companies in a space. I understand the appeal of that approach rather than getting slammed on the back end of a long case with a set of orders for a big company. But it is a recipe for regulatory capture. And I don't mean that in a pejorative way. I don't mean that it will be like the European Commission is doing Meta's bidding or Google's bidding. What I mean is that their frame for thinking about these markets will be entirely the frame in which the current market exists. And what we know in the tech space is that disruption comes from the side. And when you have a regulator that's in constant discussion with the regulated entity, the push will always be to say that whatever that weird guy out there is doing is not right, and it doesn't fit into the boxes that we know, and so you should stop it. The history of the U.S. on this, and we can get to the ex post ex ante debate on this, is rich with this. And when you look at the Federal Communications Commission, it is the entire story of the Federal Communications Commission is protecting the incumbent technology from the disruptive technology. They shut down FM radio for like a decade because the AM radio manufacturers had all the equipment in the space and they didn't want to pay for it. They did the same for broadcast TV versus radio. They did the same for cable versus broadcast. They did the same for satellite versus cable. Now they're doing it with like low Earth satellite versus incumbent ISPs. And so when you have a sector-specific regulator who is in constant communication with an industry in a specific technological frame, they're going to think about the world in the frame of that entity, and it will be uncomfortable and weird for them to deal with things that are outside of that. And I think that's an inherent break on innovation when you have that type of back and forth dialogue.
I should think it would inhibit some investment in the kind of innovation that won't later fit.
I think it's an interesting point, Neil. I think we will have to see how it plays out in practice. The distinction I would draw, though, to be on the European Commission side for a minute, is that their ability to act on the DMA and prevent or prohibit things is limited to those 6 companies or companies that qualify as gatekeepers and CPSs that are designated. So the idea that there's a startup and then the DMA allows the European Commission to say, no, you have to stop that, I think probably can't happen from the perspective of the DMA itself. I think it is an interesting point around the idea of there is a flip side to kind of the regulatory interaction. I think there's actually also a converse point, and one thing that we've seen sort of, and you can read about this, it's been covered in the press relatively broadly, the tech press, is maybe the opposite of that. There's been a little bit of kind of, one of my sort of potential concerns around the implementation is this becomes a little bit sort of trial by competitor, where the commission is going out to seek, feedback, which is entirely appropriate from other players in the market who they see as potentially the ones that would make these markets more, in their view, contestable, with quotes around that. But, as we know, right, competitors are always incentivized to maximize their own profits, their own growth, and not necessarily thinking about sort of user benefit or business user benefit. And so, there is a concern of regulatory capture on the other side if the goal or if the way the European Commission sees success or compliance is, are competitors happy or are smaller competitors happy with this?
The Microsoft Bing thing, which I was not aware of, seems like an early example of, hey, if you have the connections and the energy, you can figure out a way to make sure that you're the upstart still, even though you're the biggest company in the world.
And of course, it's true that the startup isn't going to be anywhere near subject to these regulations. But if you look at the experience with technologies that displace incumbent technologies, the time from working in the garage to displacement is remarkably short, maybe because of network effects, other reasons. And so, it was just a few years for some of them. There's a nice list of 14 examples on the International Center for Law and Economics website called Monopoly, Perpetual Monopolies That Weren't.
I remember the Yahoo has sewn up search, right? The
Oh
big
yeah,
article.
oh yeah.
and-
Even it was.
Will MySpace
Yep.
ever
It
lose?
was MySpace. It was even the tape rental companies. the ones, that were.
Blockbuster was going to be the,
Yeah,
dominant,
so the
right?
Times had an article about, was this going to be forever? And about 9 months later, they were bankrupt.
Maybe we can use that to leverage into the ex post ex ante
I think that's forbidden by the DMA, the leveraging part.
Sorry.
If you are a
Jason,
CPS.
I'm not. I wish I had that level of income. So in that, I mean, the problem here, especially in tech space, but all over the regulatory environment, is what Hayek would call the knowledge problem, right? Like, how do you make the right decision? Not just fast decisions. Fast decisions are important, but making the right decision is also pretty important. And so how do you make the right decisions given that the regulator doesn't have access to all the knowledge that might be available? And I think one of the challenges of the sort of idea that we'll all just come together and all the stakeholders will come up with a good plan is that there's always one stakeholder who's not there, which is the future, and they can't be there, and you can't really anticipate all the things that are going to happen in that way. And so we often hear this framed as like the unknown unknowns, and usually that's about risk, but a lot of the unknown unknowns are benefits, and those will not. Those are hard to know when you've missed out on them because you've structured a market in a certain way. And ex ante at least lets you see, like, it's a case-by-case approach where you can see, like, hey, this particular thing, like, we made a mistake on that case. Yeah, we killed that company. That was bad. But the next time you can review it. Whereas if you have ex ante rules, sorry, I said that backwards. But if you have ex ante rules in place, you don't have that flexibility, at least not at the same speed. And so what you end up having is less predictability because you have a rigid system in place when the technology is moving fast. And so, I don't know, there's a bunch of challenges there.
Yeah.
Sorry, I know we're almost.
I think, Neil, to a certain extent, I think I was getting at a similar point around kind of the provisions matter and the specifics matter of the provisions. And you might look at some of them and say, sort of, we're going to require more interoperability or something like that. And you might have a different view on the potential innovation effects of that. Versus, for example, I think like the data combination, no data combination across CPSs or with CPSs and other services, to my mind, has a lot more of that risk of hampering innovation. Because so much of the innovation that we've seen has been about things that you can't anticipate in that space. Maybe this data is useful combined with this other data in 4 years, right? Sort of like the Google Maps example. Like, why is Google collecting all this traffic information? Wait a minute, that's incredibly useful when you combine it with Maps information. And I can tell you now that it's going to be, a 30-minute delay to your destination. No one could foresee that. That wasn't something that you could say ahead of time is an innovation that we're going to either enable or prohibit. And so to me, I think some of these things much more look like potentially innovation offenses or efficiency offenses to sort of say, like, we don't want you to combine this data. And to your point, there's no way of telling what innovations you're going to lose out on because you weren't able to do that.
I think the Bundeskartellamt said that's a matter. Yeah. And then ultimately first reversed and then approved, right? Mic runners, Professor Lipsky over there, right here in the third row. We have someone else with a mic. And am I correct in thinking we have until 12:10? That's what the program says. Okay, thank you. All right, I was getting a mixed signal there for a moment.
Beatriz wanted to respond.
Who are these regulators? Who do you deal with at the European Commission?
Oh, good question. It's effectively a combination of DG Competition and DG Connect.
Connect, you said, yeah. And are they on the same page?
I think it depends on
It's like putting the FCC and the Antitrust Division in the same room,
Yeah,
and you get the Universal Comcast decree, which is totally anti-competitive.
Yeah, good question. I think it depends, right? It's going to depend on the provision, the gatekeeper, the CPS. So there's going to be different approaches. There are different teams working on the different sort of companies.
I'm sure you'll play them off against each other as best you can. Ted, Lipsky?
Doug, I had two questions. You just asked precisely my first question. Is it
you
going to
have
be
another
DG
question?
Comp?
You
But
do have
now we
another
know the
question. Now look,
answer.
it's $500 for 3 questions. Okay? And you've already asked 2. So what's your third question?
Okay, my third question is, what explains this kind of inchworm effect between the Commission and the member states? Because when Google and the German Facebook case started kind of going into the ditch. The Germans jumped ahead, and I think they've had at least 2 or maybe 3 statutory amendments of their competition law. So, so Andreas Mundt is in full control of this, but why would we, how would you justify, these are global markets and businesses and companies. How could you justify having a separate approach in Germany and in the and at the commission level? And I see there's some early evidence that we're starting to get into that same pattern on AI. We had these speeches last week where the officials announced that there would never be new entry into the AI market. And so college dropouts like Zuckerberg need not apply. And then immediately the French jump in with their own consultation on the same issue. Is this, multiple attacks from both the commission level and the member state levels? Is that a good thing? Why is it happening? You got the idea.
I'll respond by saying I think for one, you're right that I've heard lately a phrase that Andreas Mundt gets everything he wants because he has gotten so many different amendments to his competition law in just the past 3 years. But the way they put it is that Section 19A is complementary. So, for example, because of the fact that it has the ecosystem approach and can apply to so many more core platform services and can also require additional obligations that are tailored to a specific gatekeeper based on that ecosystem. But I think if we look at, for example, kind of a real world example, looking at, for example, in-app payments and think through how is this going to affect a company based on what's going on globally. We have South Korea, for example, with the law banning not allowing alternative app stores. We have something very similar in the EU and on Section 19A, and it's expected that the same will come from, for example, Japan and the UK. And there's a in-app developer and marketplace payments on marketplace developer that I was reading an article on called Paddle, who was, for example, really happy that all of these jurisdictions were going to be requesting something very similar, which would allow their entry into the different markets and for them to continue to innovate. So I think ultimately we'll probably see similar solutions, though some of them will be complementary.
Another question?
Hi, very quickly. So my question is on the litigation side, as Neil mentioned, there is a litigation part of the DMA that entails the 27 member states' legitimacy to bring out suits, to have suits against these gatekeepers. And my question is whether that overlaps with the private enforcement. And this year we just had 10 years from the European directive. So my reflection on this is we have just inserted a new pill. We had done a lot of work in order to the European directive to come out and to enforce private litigation in Europe. And now there's just this new DMA with a new private litigation, and there are overlaps between them. How is this going to help the system or just create more friction? Just like focusing on the litigation side of it, not the public enforcement side.
It's a good question. I actually don't know much about that, about the directive and how the litigation piece works. I don't know if you guys know more.
My understanding is that this would be in line with the directive and thus it wouldn't create friction. It's just a private right of action similar to what you have in the directive. But I'm happy to hear from you more later about the frictions you've seen.
It does seem at a high level there is continuing friction between the idea of having a digital single market and having all of the law, some of the law at least develop in the member countries itself. So.
Alexander Krispiski and then Alden Abbott.
So what's the potential for regulatory arbitrage under the DMA? Like, could the New York Times set up an office in Brussels, get all that click and ad data from Facebook and Google, and then bring it back to the United States and use it in its negotiations here?
So I don't think there's any prohibitions on sort of use of the data if you do get it. On the sort of regulatory arbitrage point, I suppose it is quite possible. The thing I will say is the companies have been sort of getting very good at offering differentiated experiences based on the different requirements in either different member states or specific geographies outside of Europe. So even if you look at the DMA solutions that have been rolled out to date, they're being rolled out on a jurisdiction by jurisdiction basis, right? So the relevant law is within the European Union. All these new consent screens and dialogues and requests for permission to join data across services is limited to Europe. It's not being rolled out outside of that. I think you're going to continue to see more and more of that, not less of it. I think every single gatekeeper compliance plan anticipates that. No one has suggested that they're going to apply any of these requirements outside of Europe. Tad, to your point, we've also seen that within Europe, right? So there are different experiences within Germany that do not apply outside, certain products that can be sold in different places. So I think the companies also have built a much better muscle over the last 10 years of being able to, in a relatively flexible way, have targeted solutions on a lot of these compliance issues.
And I'll just add that that's something that big companies can do much easier than small companies.
And if I may add, I'd just like to underscore again the example that Judge Ginsburg mentioned, which was the Meta Facebook linkage of the account with the Quest 2 or the Oculus in Germany. And I think that's kind of a real world positive example where, yes, they took out the Quest 2 out of Germany for around 2 years, while the Section 19A proceedings were ongoing in relation to the specific conduct by Meta. However, by 2022, they re-entered the German market and actually changed course and took away the policy of having to link accounts, and this was global. So there was a positive effect globally, thanks to, at least Germany has taken credit for this, thanks to that Section 19A investigation, and it had also followed some customer backlash.
That's the sort of thing that passes as empiricism in the law. Alden?
Thanks, Judge Ginsburg. Alden Abbott, Mercatus Center, harking back to another European, Panelists, Bastia, who talked about the seen and the unseen. The European Commission has had statements of 2030, wanting to be digital leader in 2030. Alden Abbott, Mercatus Center. So about the European Commission's statements about digital leadership in 2030. Isn't there and the fact is, no platforms appeared from Europe. Now we find concerns, sort of the precautionary principle about acting, and yet we find, for example, that recent article in Competition Policy International that looked a lot of innovation in AI is not being done by the big platforms. So the assumption that the big platforms are going to be able to leverage their monopoly or market power in one area into other areas is open to question. And to what extent do you think the European Commission in its deliberations about the DMA and other things is seriously considering the effects that new regulation can have on innovation and the ability to meet the 2030 Digital Europe goals?
I'm guessing that one was for the fellow European, even if sometimes I like to take out my other passport and say the American. Well, I think that the European Commission believes that the DMA itself will foster innovation, for those companies like Paddle that I mentioned, and others. And if you're making the market contestable, ideally there should be more competition. So I don't think that this contradicts their 2030 goals or otherwise. And as we continue to hear from EVP Vestager and President von der Leyen, et cetera, it will remain a goal of the future Commission. But to be seen what happens with the European elections.
I might add just a little bit that we've talked a lot about, and I gave the tour as if these ideas hadn't been in the U.S. at all. And actually, when I was looking back and preparing for this, a lot of the discussion around 2019 and 2020 in the U.S. about trying to create a digital regulator was very similar in scope to the way that the DMA has done this. And so I was actually pulling from a paper that I had written about that, about the importance of defining a specific sector when you're going to apply very detailed regulation. At least in the U.S., that is the overwhelming justification for Congress delegating something. It's a different situation. But in the U.S., if you're going to delegate something to an agency, you have to have them be an expert in something. Otherwise, might as well just keep all the decision-making at Congress. And if you can't define the sector, you can't really define what the expertise would be. It's a little different in the U.S. That argument doesn't actually work in Europe because the European Commission is, executing on an ongoing basis. So I just thought that was interesting.
Yeah, I think the AI point is a really interesting one for the future. It does seem like one regulatory trend that we're seeing is that every sort of new innovation in AI or new launch in AI, the immediate reaction is, there must be some competition problem here. We got to quickly find the competition problem, right? Instead of sort of, I think, seeing the fact that you have one of these announcements every week or every couple of days is actually a sign of how vibrant this space is in terms of new entry and new innovation. We've seen more VC investment into AI than any other field in the last, at least 2 to 3 years. And clearly that's all going to startups, to new companies, to people that are trying to build something from nothing. And I think there should be a little bit more recognition about sort of the benefits of that innovation and where it's happening, and why and what the dynamics are around that. And I think there's also a lot of room to really be talking more about kind of open source in that context too, in a way that maybe hasn't been part of the conversation so far.
One thing, the AI conversation in Europe, one great example of that sort of difficulty of predicting the future was that the AI Act in Europe was quite a long ways along before ChatGPT was launched, and they didn't even talk about generative AI in the AI Act. So they kind of had to really dial it up and try to get something that still applied to this incredibly new environment that they were in. And I mean, that job is hard.
So Nikhil, what you just described in terms of how regulators in particular see the competition problem with anything new is what Donald Turner, former head of the Antitrust Division, called the inhospitality tradition in antitrust. And he thought it was a good thing. George Stigler commented on it later, and he was not so happy about that idea. And it's had a long history of making it difficult for innovations to take hold. Case in point, just as simple a thing as the franchising model in the early 50s that grew up with the highway system. There must be something wrong here, right? You have to buy all the spoons from the franchisor. How terrible is that?
Hi, thank you. I'm Natalia Moreno. I'm doing my PhD at the European University Institute in Italy, so I guess I'm one of the few Europeans in the room. And I think the panel goes to show that there's no escaping the DMA even after a 10-hour flight. So I think something that perhaps all three panelists mentioned is that this move towards the ex-ante approach opens opportunities for more dialogue with the companies being regulated. And I think this is very needed, and indeed the opportunity is there under this type of approach to antitrust, because it's a more proactive way of doing antitrust. It's about shaping market dynamics, not just policing infringements on these markets. But I wonder whether the design of the DMA, and I would love to hear your thoughts on this, whether the design of the DMA actually provides enough room for this type of dialogue. And I'm thinking especially about the compliance with the obligations, because at the designation stage, we've already seen some room for flexibility with these designations being undone for some of Apple and Microsoft services. But I'm mostly thinking about the obligations because there's no efficiencies, there's very limited room for commitments. So yeah, I would love to hear your thoughts on that.
I'm happy to start. I think this is actually a really good connection to Beatriz's presentation about the different models that are being considered in different places. And so I think that is going to be something where there should be some interesting work about the comparative models between, say, the DMCC in the UK and the DMA sort of across the channel, and how those things might play differently. Because I do think not just the efficiencies defense, but also the idea of delegating the actual commitments or the actual conduct prohibitions or requirements to the expert agency, Neil, to your point, rather than trying to write that as primary legislation is a very important distinction between the two. And I think we will see if you get sort of a more reticulated, less one-size-fits-all approach where the actual requirements much more take into account, is Bing search really the upstart here? Should we even be having a 9-month conversation about whether it's a CPS or not, right? Is that just wasted energy? Can the CMA just decide no, Bing search does not have requirements around this in the way that maybe Google search does, right? So I think that comparative piece is going to be important.
Well, is there any provision in the DMA comparable to, I think it's 1013, for exemptions? Block exemptions or any other kind of exemptions?
No, there is no exemptions. There's only like a public policy and security, very narrow exemption within the DMA, but it's not comparable in the
That's
same way.
remarkable when you consider how important that's been in making the underlying 101, 102 workable in practice.
Maybe they'll start writing comfort letters.
Pardon me?
Maybe they'll start writing.
Comfort letters, yeah, all right. Alex, last question.
First, a factual question. I'm not really that familiar with the DMA, but it sounds like much of the restrictions are on how data can be used. Is that fair? And, okay, if it is fair, is data as an asset, a productive asset, fundamentally different from, let's say, a certain type of production line or a factory where, yes, competition on the merits would push toward a company once it discovers, oh, I can use this asset in a new way, to do a new thing, to produce a new product. Oh, but that's going to weaken competitors. But that's competition on the merits. If the heart of the DMA is restricting how these data assets can be used by the gatekeepers, I can see how that diminishes their incentive to innovate, and maybe by hobbling them, it helps European companies to innovate more. But does that really mean that there's an increase on net in innovation?
So I think, Alex, this is, I'm sorry if I was not clear about it, this is exactly what I was sort of getting at with the efficiency offense idea. And I think it's particularly relevant to data because of that flexibility that data has, the ability to sort of innovate so quickly and do things that you never thought were possible or that become possible with new technologies that can then use old data. And if you have sort of very strict requirements around when this data can be used, how it can be used, what it cannot be used for, without an understanding of Neil's very good point about what's possible in the future, I think it absolutely has the potential to dampen innovation and hold back innovation, and as you said, in the name of the fact that this innovation is being done by a gatekeeper company, so it can't happen.
And prior to the DMA, there were accumulations of data that were unprecedented in history, and now they can be used in large language models because Alphabet has them, Meta has them, others have them. No one can replicate that. They might be able to lease it or get access to it under the DMA. That may be the way that the commission's responded. Well, time is up. Lunch is available across the hall in the multi-purpose room. It's going to be a brief break for lunch so that we can get back to business as soon as possible. Please join me in thanking this panel. Great job.